Well, hello there, a very good morning to you, and thank you so much for joining us this Tuesday, the 23rd of August 2022. My name is Kirk, and welcome to Kirk Mid Morning. Definitely coming live to you from the studios in Nairobi, South Sea. Definitely do interact with us on our social media pages, that is YouTube and Facebook at Kirk TV Kenya. On today's program, definitely an interesting conversation on matters the presidential petition. This is Azimio versus IEBC, or rather the people versus IEBC, as the Azimio la Umoja One Kenya coalition put it yesterday when they filed the petition. Definitely we'll have a look at that, and I'll be speaking to Victor Hezekiah, who's an advocate of the High Court, as well as a constitutional lawyer, in a few. But right about now, let's have a look at the news bites, some of the stories that are making headlines. Indeed, even as we get to talk about the presidential petition, get to understand where are we and what does it mean for Kenya in the next few days before the verdict by the Supreme Court. Do interact with us on our social media pages, Kirk TV Kenya on Facebook and YouTube. Without further ado, let's look at the UK speaking on presidential elections. Now, the UK High Commissioner in Kenya, Jen Marriott, has dismissed claims that the United Kingdom had a preferred candidate in the just concluded polls. In a statement, Marriott said that the fifth president is entirely tied to the choice of the Kenyan people. Her statement is following claims that the UK and the High Commissioner had William Ruto as their preferred presidential candidate. Now, according to Marriott, the Commission has been meeting politicians across all outfits to explain the UK's programs and partnership with Kenya, including independent institutions. Well, now the Independent and Electoral Boundaries Commission, IEBC, has proposed Monday, this is the 29th of August 2022, as the date to conduct the election in the remaining wards, constituencies and counties. The Commission proposed the date in a meeting with the candidates. This is with Mombasa and Kakamega gubernatorial races, eliciting political reactions. IEBC had postponed the elections after the ballot papers mixed up in Mombasa and Kakamega counties. On the list are parliamentary elections in Kitui Rural, Kachiliba, Pokot South, and Rongai constituency in Nakuru County. Now, the Commission had earlier on set August 23rd, 2022 for the election. This is before suspending them, citing insecurity reasons.
We also wanted to have our colleague who was killed buried before we could go to another election. There were other circumstances that also made us not to be ready. As you are aware, they could not be available to do what was get. We have to get all the SD cards from the affected areas, KIMS kits, so we could not manage this in time. Partly, we also didn't have budget. We have not made a budget that made us not to be in a position to conduct as was communicated earlier in the general elections. But having said that, we still need, although the procedural issues, so that the elections can go valid, and all these circumstances are the ones that made us not to be able to conduct the election as was earlier. And of course, more importantly, to have a way forward.
Of course, ballot paper, they arrived on 20th and 21st. So yesterday we also we received another batch. So in terms of ballot papers, we are basically ready. And I think it's just a matter of agreement. That's why we're having this meeting. We want to thank you for showing leadership, because whenever there is crisis, we also now see importance of leaders.
Well, today's program is on the presidential petition, and we'll be seeking to understand what next for Kenya in the coming few days. This is before the verdict. And what does it mean now that we have a petition and we're looking forward to hear the verdict by the Supreme Court? But before we get to look at the timeline, let's, look back to the 9th of August, where elections were held. It was indeed the big day where Kenyans came out in big numbers to vote for the preferred candidates in the different positions. Now, From August 9th, the tally process continued to the August 15th, where the IEBC's chair, Mr. Wafula Chebukati, declared Deputy President William Ruto as the president-elect. This happened at the Bomas of Kenya. August 16th, the presidential candidate of the Azimio la Umoja One Kenya coalition, Raila Odinga, rejected the presidential results publicly in a conference at the KICC, definitely giving what can I say, political commentators stating that that could possibly result to a presidential petition from the coalition, which was witnessed yesterday as the petition was filed at the Supreme Court by the Azimio la Umoja One Kenya coalition. Presidential candidate Raila Odinga, thereby flanked by his running mate Martha Karua, as well as Kalonzo Musyoka and other affiliates of the coalition. Now, from yesterday, we have until a pre-trial conference will be held and the court will determine the petitions within a period of 14 days. The court has to hear and determine the petition within 14 days. And there are two possible outcomes from the hearing of this petition. Now, one, the court can decide to nullify the elections, which was witnessed in the country in 2017 as well. So the court can decide to nullify the elections. This then will result to IEBC holding fresh presidential elections within 60 days. The second possible outcome is that the court then, after hearing the petitions, can determine to uphold the election. And then this, of course, will lead to the president-elect, in this case, Deputy President William Ruto, to be sworn in on the first Tuesday after or within 7 days. Now, when we go to court matters, when we look at after the petition was filed yesterday, there is 1 day to serve a respondent. This is today, the 23rd of August, Tuesday, 2022. Then the respondent has 4 days to respond to the petition filed and serve. So the 4 days will be elapsing on Saturday, the 27th of August. Have in mind that these 14 days also include the weekend days. And after that, a rejoinder will be filed and served within 1 day. So if you're to follow the timeline, this is by Sunday, the 20th of August. And then after then, an interlocutory application filed and served within 1 day as well. The Monday, 29th of August. Then, after the interlocutory has been filed, a response to the interlocutory applications will be filed the following day within 1 day as well. This is the Tuesday, 30th. After that, now the pre-trial conference will begin on the same day, probably, or the following day, where now here comes in the third party who are friends of the court to file the application as well. Friends of the court now come in on Wednesday, the 31st of August. And from then on, hearing and determination of the petition. Remember, the Supreme Court or the Apex Court has until 15th September. This is on Monday, 15th of September, to give out a verdict. Definitely, that is what is building our conversation this morning right here on Kirk Mid-Morning. Joining me in a few right here on set is Victor Hezekiah, an advocate of the High Court. We're taking a very brief break. Do not go too far. Definitely interact with us from yesterday's proceedings, as we saw the Azimio la Umoja One Kenya coalition file a petition at the Supreme Court. What's your take on that? You know, do interact with us on our socials. Kirk TV Kenya. We'll be back in a few. Keep it right here.
Choose life, that you may love the Lord your God.
If you delight yourself in the Lord, He will make you fruitful in whatever season you are in.
Listen to His voice and hold fast to Him.
That as disciples ourselves, we're being invited to be transformed more fully every single day.
In our walk with God, let us know that we are assured victory in every battle.
For the Lord is your life.
Live a pure life. Are you living a righteous life before the Lord? It is possible. People are wondering, can you do without corruption? Yes, I can stand and say it is possible to do without corruption.
Don't miss season 2 of the evening epilogue every day at 9:30 p.m. only on Kirk TV.
Because a new page of history gets written every day. Because breaking news can't wait. Information everywhere. In all situations. On every subject. Understanding the world. Imagining the world. France 24. A different take on the news.
Liberté, égalité, actualité.
Are you looking to grow your business? Kirk TV offers you a variety of advertising opportunities to suit your budget. Advertise with us today and reach your potential customers countrywide. For more information, email us on sales@kirktv.org or call 011 00 90 647. This year 2022, the Presbyterian Church of East Africa honors the anniversary of women clergy, 40 years in the ministry. As part of this anniversary year, the Presbyterian Church of East Africa, led by the moderator of the 23rd General Assembly, Right Reverend Patrick Degumutahi, in collaboration with the Presbyterian University of East Africa, hosted by the Vice Chancellor, Professor Henry Timothy Gatara, invites you to a symposium event to commemorate 40 years of women clergy in ministry. The event will take place on 1st and 2nd September 2022 from 8 a.m. to 5 p.m. at the Presbyterian University of East Africa. The message of the day will reflect on the theme, Ebenezer, let her celebrate, rejoice and witness for Christ. John chapter 20 verse 11 to 18. The event's keynote speaker will be Reverend Dr. Nyambura Jane Joroge and will also include invited guest Bishop Dr. Emily Onyango. Be sure to catch the event live on Kirk TV on Signet as well as Kirk TV Kenya on Facebook and YouTube.
Seen even in 2013 and 2017. Yeah.
All right.
Are you looking to grow your business? Kirk TV offers you a variety of advertising opportunities to suit your budget. Advertise with us today and reach your potential customers countrywide. For more information, email us on sales@kirktv.org or call 011 00 90 647. This year 2022, the Presbyterian Church of East Africa honors the anniversary of women clergy, 40 years in the ministry. As part of this anniversary year, the Presbyterian Church of East Africa, led by the moderator of the 23rd General Assembly, Right Reverend Patrick Degumutahi, in collaboration with the Presbyterian University of East Africa, hosted by the Vice Chancellor, Professor Henry Timothy Gatara, invites you to a symposium event to commemorate 40 years of women clergy in ministry. The event will take place on 1st and 2nd September 2022 from 8 a.m. to 5 p.m. at the Presbyterian University of East Africa. The message of the day will reflect on the theme, Ebenezer, let her celebrate, rejoice and witness for Christ. John chapter 20 verse 11 to 18. The event's keynote speaker will be Reverend Dr. Nyambura Jane Joroge and will also include invited guest Bishop Dr. Emily Onyango. Be sure to catch the event live on Kirk TV on Signet as well as Kirk TV Kenya on Facebook and YouTube.
All right, welcome back, and thank you so much for keeping it right here. This is CAC Mid Morning, and right about now we delve into a topic of discussion today, the presidential petition, where we look at, of course, the Azimio versus IEBC, or how they put it, the people versus IEBC. We'll be touching as well on the other petitions that have been filed and look at them as well. And to steer this conversation in the right direction, with me is Victor Hezekiah, who's an advocate of the High Court. Karibu sana.
Thank you
so much for joining us.
Thank you for having me, Faith.
You're well?
I'm well. Thank you so much.
Okay.
You're well?
I am good.
Okay.
Yes. So let's look at what happened yesterday. Of course, we saw the Azimio's presidential candidate, running mate, and his affiliates as well file a petition at the High Court. Interesting enough, they termed it the people versus IEBC. I think I'd like us to start with, as an advocate, what do you make of all that? What's your take?
First, the petition was filed at the Supreme Court. It was not filed at the High Court. I think that was just a small error. It was filed at the Supreme Court. You know, presidential election process generally is a political process. And petitioners are allowed to be political as much as legal when they come to court. So I think the phrase "the people versus Chebukati," in my view as a lawyer, is exclusively a political phrase, and they're entitled to that. Looking at the petition, they have sued Chebukati as an individual as well, and a lot of the substantive aspect of the petition attacks the conduct of the chairman Chebukati as an individual. So I think that is why they found a politically befitting phrase, Chebukati. The people versus Chebukati. Of course, with the understanding that if they won the election, and they were denied the victory, then it's the people who were denied the victory. So it is really not about the petitioners, but the people whose victory was denied. But it's a political phrase, not necessarily a legal phrase. Yes.
Okay, that's about the people versus Chebukati.
Yes.
I think you put it very well. When we talk about you as a lawyer, what do you make of all this?
What I make of all this is that, we are a democratic nation, and the good thing that we have now is that every person, the Constitution allows us, any person who feels aggrieved, or even who is interested in challenging the presidential election, to file a case in court, file a petition in court. So what I make of what happened yesterday is a clear demonstration of our maturity as a democracy, as a democratic nation, and as a nation that observes and upholds the constitutional dictates. I think it is far much better to go that route than to go to the streets. That we express our grievances through a constitutionally allowed process. Yes.
All right.
Yes.
I think a lot is being said on social media. Of course, talk from a few lawyers as well, who are followed hugely on social media. And I'd say innocent Kenyans who probably do not understand the whole process of what is required to happen next. When we talk about the constitutional right of the Supreme Court, in terms of when it comes to a presidential petition, tell us more about that.
What is in social media, you are allowed to say anything. I would say it's unfortunate that there are also lawyers who go that route, but again, it is also their right. When you are dealing with social media, the social media does not discriminate between professions. You are allowed to say whatever you want to say. We have the freedom of speech. But when we come to court, then it is not really what you say. It is not just what you allege. The court has procedures of how cases should be had. You present your case. You are allowed to make any kind of allegation, but it is not by virtue of the fact that you have alleged that you will win a case. It is that which you have corroborated, that which you have provided evidence in support of that allegation. So when we are on social media, that's okay. We can do anything. We can say anything, of course, within the confines of the law. But when we come to the court, the petition itself, it is that which you have provided sufficient evidence. The evidence must meet a certain threshold that has been also provided for by the law. So it is not that which has been alleged that will carry the day. It is that has been averred and supported by evidence that meets the legal
The
threshold.
legal threshold.
Yes.
And when we are talking about the Supreme Court, the
Yes.
7-judge bench,
Yes,
right?
yes.
Who are going to listen to the petition
Yes.
and, of course, come with a verdict. What are their powers? You know, because of course, when we look at social media, and for me, this whole program is to make Kenyans understand, of course, what we're expecting and what powers they hold. People are talking of, you know, them declaring Raila as the president-elect.
Yes.
Let's talk about what powers do they hold.
Now, the 7-judge bench at the Supreme Court have powers given to them, donated to them by the Constitution. And after listening to the presidential election petition, there are several probable outcomes from that determination. One, it can be, the entire process can be invalidated. If the petitioners present a concrete case with sufficient evidence that meets the threshold, then as we saw in the 2017, the Maraga bench, the entire presidential election was invalidated. It was declared as null and void because of the irregularities and the illegalities that were substantial to the extent that they affected the outcome of the results. So that is one of the possible outcomes, and that is given by the Constitution directly.
All right.
Now, when you come to the Elections Act, Section 80, subsection 4 of the Election Act, talks about a possibility of an election court conducting a recount of the votes.
Okay.
And should that recount reveals a result contrary to that which was declared, then the Act donates power to an election court to actually give or direct the Commission to issue a certificate of an election certificate to that candidate who has been found to have won cleanly the elections through the recount.
Okay.
Now, the Act defines an election court as including Supreme Court when it is sitting on a presidential election petition. There are conflicting views about it. Even lawyers I've seen on social media are conflicted. But my personal opinion is that if the Act defines an election court to include Supreme Court, and the only time the Supreme Court is considered as an election court is when it is dealing with a presidential election petition. If the Act defines the court to include the Supreme Court, then in my view, the Supreme Court has powers should it order a recount, and should that recount reveal that the petitioners were denied their win, then the Supreme Court has powers to direct the Commission to issue a certificate to the petitioner.
All right.
That is my view.
Yeah.
Yes.
Now, speaking about the Supreme Court issuing a recount of the votes,
yes,
we see we have a margin of 14 days constitutionally for them to make a verdict or announce a verdict. Is that really, is it a possibility or a probability, you know, and if a recount is ordered, can this happen within the timelines?
Now, you know, these are now some of the challenges that we have. We are growing as a democracy, and as we move on, as we move along, we realize areas where we need to improve in. And one of the things that I think the general public, and especially the lawyers, are agreeable on, is that the 14-day window is too small to actually do something substantive. But now that we are here, and the petitioners have actually put that as one of the prayers, they have thrown the ball to the court. It's up to you. Is it logically and practically possible? Maybe under extreme pressure. And what I foresee happening is that maybe at the interlocutory stage, then the court may allow a recount. Then the recount can happen concurrently with the hearing. So that at the end of the hearing, maybe, then whatever the result the recount will have revealed may be considered and factored in the final judgment. But if we say that we are giving time for recount alone and then spare time for hearing and all these things to happen within, and I insist 7 days, because 14 days 7 of those 14 days is in-house things, you know, replies to the petition, rejoinders, conference, the case conference and everything. So we only have 7 days, within which to actually do all these substantive things. I think it is extremely difficult, but I would not say it is insurmountable. Okay. Yes. If measures are put in place, perhaps it's possible, but at extreme pressure.
All right. Yes. But would you suggest, of course, hearing from your response, that the 14 days limit should be reconsidered?
It should be reconsidered. It should be reconsidered. Of course, there's a balance between giving enough time for the parties in the court to have, to digest the matters, digest the cases, do a hearing, and give some substantive, reasoned out judgment. You balance that with also the political aspect of it. This long wait between declaration and Supreme Court judgment, what is it likely to do politically to the anxious public? So I think when you balance the two, we should be able to find some compromise, because also the time should not be so much long that the country or the nation, the anxiety is so much prolonged. Right. We all know how our nation is anxious, even as we wait for the declaration. And remembering the Maraga bench, the country was so anxious, and when the elections were nullified, it was like another celebration of its own. So these processes are not so good when they are so much elongated. But I think that there's need to review that, maybe in our first constitutional amendment, as and when that will be. That is one of the things that should be given an objective assessment. Okay. Yes.
Let's go back. I think we are setting a very good foundation, and just to encourage our viewers, in case of any questions, definitely do leave them on our socials. Facebook and YouTube is CAC TV Kenya. We'll be having a look at them even as we continue to talk about the presidential election petition. Let's go back to the August of 9th, where of course all this started, and we look at the whole process of tallying and collection of votes at the Bomas of Kenya, the National Tallying Center. One thing I'd like to understand, there is a conflicting opinion expressed by Kenyans when it comes to the 7 days for the National Returning Officer, IBC's Wafula Chebukati, to announce the president-elect. Was it Monday the 15th or was it Tuesday? The 7 day, do we start counting from the day of election or the following day?
The 7 days begin from the day of election.
All right.
The 7 days begin from the day of election. Elections are held on Tuesday. The end of the first day is Wednesday. Because if you say that elections began on Tuesday, 8 a.m., that's when the polling stations were, let's say 5 p.m. In my view, the 7 days, the end of the first day falls on Wednesday, the following day.
Yeah.
Yes, that's in legal instruments, days of course will also include the weekends and all that. There's a conflicting position as to whether it was supposed to be Monday or Tuesday, but I think 7 calendar days is not Sunday to Sunday, but Sunday to Monday.
Okay.
Yeah.
All right.
I mean Sunday to Saturday.
Sunday to Saturday.
That's 7 calendar days. Because if you go and include the other day, then you are actually talking about 8 days.
8.
Yeah.
Okay. We look at now, of course, Chebukati, under immense pressure amidst the chaos, still holding fort and coming out to declare Deputy President William Ruto as the president-elect. Of course, this is alone. We saw earlier on the 4 commissioners distancing themselves from that. 2 other commissioners where he said were hospitalized. Let's look at what effect does this have when it comes to the presidential election petition.
Now, one interesting thing about this petition, and different from the previous petitions, is that the petitioners have not only gone against the commission, they've also gone against the individual commissioners.
Right.
The lack of unity in decision making by the commission does not affect the declaration. Okay. And the difference between the declaration and tallying and verification.
All right.
The tallying and verification must precede the declaration. The tallying and the verification of these votes is an exclusive responsibility of the commission. The commission is not synonymous with the chairman. Okay. However, upon tallying and verification of the votes,
Right.
the responsibility now shifts to the chairman to do the declaration.
Yes.
So, in my view, the fact that there was no consensus among these commissioners does not affect the declaration, okay, to the extent that the declaration is a responsibility of the chairman as an individual, but it does affect the process that must precede that declaration.
Okay.
And you see, if the process is wrong, a wrong process cannot give birth to a good right thing. So my personal opinion about it is that the process, the means must justify the end. I mean, both the means and the end are actually as important. The tallying and the verification did not meet the threshold, to the extent that the four did not participate, but the declaration in and of itself is an exclusive job of the chairman. How that will play out in the petition, of course, both parties will have their day in court to argue, and the court will have to be convinced by either party. Again, the standard of proof is that of not so much as to go beyond the reasonable doubt, but also not so low, just on a balance of probabilities. But this is a point of law. We will see how it plays out in court.
All right.
Because each party will have their day in court.
Yeah.
And be listened to. Yes.
If we were to preempt or look at the possibility of how things might turn out to be, we look at you mentioning that this petition, of course, individuals have also been mentioned, not just the commission. Yeah. And we look at all commissioners have been mentioned at one point as either interested parties or respondents. And we look at of course, the four commissioners who had distanced themselves from the presidential elections or results, rather declaration. In court, is there, would we say this is a threat? Probably the four commissioners will come out with evidence that would be of interest to now, let's say, Azimio.
You see, ours is an independent electoral and boundaries commission.
Right.
That independence should include independence from the petitioners.
All right.
All those political stakeholders. The commission should be independent of them. The commission is comprised of the commissioners as well as the secretariat. Now, it is my view that as much as they have been mentioned and they do have a right to defend themselves, their defense in court should not be interpreted as supporting the petitioner's case. Coincidentally, they may say what the petitioners are saying, but their role is not and must not be to support the petitioner's case. Otherwise, there will be no independence, and they will actually be doing something worse than what they think they should do. So I think by virtue of the fact that they've been listed as respondents, they have a right to file their responses. Their responses may coincidentally align itself with the petitioner's case, but they should not go out with an intention to support the petitioner's case.
Okay, and that is very well put. Let's look at the basis on which the Azimio filed the petition. That, of course, the election process was not just and transparent. Would we say those are adequate, looking at every other thing? Would we say it's an adequate base to either nullify the presidential election?
Now, when you say that the electoral process was not just, and it should be free, fair, independent, transparent, accountable, verifiable, and all those adjectives. The grounds upon which an election court can or should nullify an election are clear. And the first one is when there's breach of the Constitution and the Election Act, the electoral laws. That in itself has a problem because it is just left at that. The breach of, substantial breach of the provisions of the Constitution and the Elections Act. But two, there's something called the substantive test. Whether the breaches alluded to did in fact have an implication on the result. Okay? There are also irregularities and illegalities that may happen in the course of an election process. The question is not whether there were illegalities and irregularities in itself. The bigger question, the bigger picture, what the court will look at is, did they, if at all they were there, did they have an implication on the results that were declared? Now, if they had an implication on the results, the next question is, did that implication, if that implication factored in, did it deny us a candidate, or did it give us a candidate who managed a 50% plus one fraudulently? Okay, because the threshold is you must attain 50% plus one vote.
Right.
Now, if you attend that through those illegalities, then the election will automatically, or should be, nullified. Because it means that your achievement of that constitutional threshold was not fair, it was not just, it was through irregularities. Absence of which you may not have attained the constitutional threshold, and therefore will nullify it. The next thing is, if the irregularities may have been intentional, willful, deliberate, with an intention of committing a crime, that is different from irregularities that are as a result of human error. Now, if it is the former, then it will still go back to what was the implication on the result. There's the qualitative, quantitative. Did it affect the actual votes as declared?
Right.
But also, assuming that sometimes even where the results, we cannot establish whether actually the votes were affected, the qualitative test. Were the irregularities and all the breaches so serious, so substantial, that we cannot even tell what were the real results? You get? So we can't tell whether the results were affected, because in any event, we can't even tell what should have been the real results. So, yes, on the ground of lack of transparency, I will say that it is not merely the lack of transparency that will lead to invalidation. It is the proven lack of transparency as well as the implication it had on the outcome. Yes.
And of course, yesterday we had the team saying that there's a whistleblower who is willing to speak on how they deliberately interfered with the results in order for them to favor one candidate. So when it comes to that, if indeed there is a whistleblower and they'll be able to prove that they interfered with the results, having in mind, of course, the IEBC speaking during the whole tallying and collation process said there have been attempts, but they were not successful. How will that play out if this whistleblower indeed has evidence enough that show the final outcome was interfered with? Then of course there will be a nullification.
So far the evidence that has been presented to court by the petitioners has been presented by way of affidavits. As we said, even a whistleblower who is now coming out to say the truth, those are allegations, averments made in an affidavit. They still have to be tested. The court, the Elections Court, the Elections Act gives powers to the Supreme Court or any election court to summon any witness for purposes of examination and cross-examination. So this whistleblower will, and I hope he has, sworn an affidavit. That affidavit should be scrutinized and put to test, so that the respondents who have been adversely mentioned, including the commission and the commissioners maybe, they will have an opportunity in court to cross-examine this whistleblower based on what he has said. Now, depending on what the whistleblower says and what comes out from his cross-examination, as I said, the election court will assess both ways. Which side is more believable? The standard is not beyond reasonable doubt, neither is it the lower of on a balance of probabilities. So if his story is more believable to the court and meets the requisite threshold, then the next thing is, were those interferences, okay? Did they affect the final outcome? If they did, then the election court should nullify the result. If they did not, then it will have affected the qualitative aspect of the election process. But if the court is satisfied that it did not affect the result, then the court may not nullify the result.
Okay. I think let's take a very short break. When we come back, I'd like to hear from you as now a political commentator, other than a lawyer. What's your take on if the presidential elections are upheld? What then does that mean for Raila Odinga? You know, we're taking a very short break. Keep it right here, Kirk Mid Morning. Interact with us on our socials. Send in comments, questions, feedback, Kirk TV Kenya. That's on Facebook and YouTube. See you in a few.
We welcome your feedback on our programming. For questions or comments, kindly get in touch with us via email info@kirktv.org, SMS 0111 220044, or call us on 0794 588 054. Choose life, that you may love the Lord your God.
If you delight yourself in the Lord, He will make you fruitful in whatever season you are in.
Listen to His voice and hold fast to Him.
That as disciples ourselves, we're being invited to be transformed more fully every single day.
In our walk with God, let us know that we are assured victory in every battle.
For the Lord is your life.
Live a pure life. Are you living a righteous life before the Lord? It is possible. People are wondering, can you do without corruption? Yes, I can stand and say it is possible to do without corruption.
Don't miss season 2 of the evening epilogue every day at 9:30 p.m. only on Kirk TV.
I am not a mistake. Welcome to Kirk Watoto. We're very glad to have you. In this show, we have 4 segments.
I always get excited for this particular moment when we raise generation for Christ.
You know that Jesus loves you so much and He has given you talents.
The aim of this program
Celestine Kemunto. I'm taking a bachelor's in business information technology. I chose ZTech because, first of all, ZTech has been ranked among the best in ICT, and I thought it will be best. It will be best for my course. First of all, there are so many ICT labs in ZTech University, which enables students, mostly those who are pursuing IT courses, to get to know more about their courses, of which the labs have so many computers which have Ethernet, which is easier for them to browse. If I were given a chance to choose another university, I'll definitely choose ZTech University.
Apply today. ZTech University. Invent your future.
Welcome back, and thank you so much for keeping it right here. Definitely keep interacting with us. That is at CAC TV Kenya on our socials, Facebook and YouTube. That is, with me is Victor Hezekiah, an advocate of the High Court, as we get to understand the presidential election petition. Mr. Victor, there are several petitions that have been filed. Let's look at how will that play out when it comes to which one will be given first priority and all that.
I think in total so far there are about 8 petitions.
Right.
And I think that there should be no more because the deadline for filing petitions was yesterday.
Yes.
So we have around 8 petitions. Ordinarily what is likely to happen is that the Supreme Court is likely going to consolidate the petitions so that they are heard together. When they are consolidated, they will pick one petition as the lead petition.
Okay.
But each petitioner will have his day in court to present his case. So they will be heard as though it's one consolidated petition, but with one lead petition. So the court will decide which one will be the lead petition.
All right.
Yes.
Okay. When we talk about the petitions, we see Moses Kuria, Chama cha Kazi party leader, who has also filed a petition wanting the Supreme Court not to hear the petition, presidential election petition filed by the Azimio la Umoja One Kenya coalition. Let's talk about that.
I've not had an occasion to actually read through Moses Kuria's, Honorable Moses Kuria's petition, but from what I see, from the discussion I see online, the law talks about, the Constitution provides for a room to file a petition challenging the presidential election. Now, if his petition does not challenge the presidential election, the question that the court may be forced to answer is whether the court actually even has jurisdiction to hear such kind of a petition. Because the petition that the law envisages is that which challenges the outcome of a presidential election. He is not challenging that.
Okay.
If to that extent, then this is the first time we are going to face that kind of an issue in court. Then it's a wait and see what will be the court's take of that kind of petition.
Yeah.
Yes.
All right. Maybe just a few things he's stating is that the case, or rather the petition, should not be listened or heard because the Azimio la Umoja One Kenya coalition violated the Constitution, the Elections Act, as well as the Code of the Electoral Conduct. And he's speaking about the violence that occurred at Bomas, saying that due to those facts, then this petition should not be heard.
Legally speaking, there's a big difference between Azimio la Umoja One Kenya Alliance and Raila Odinga and Honorable Martha Karua. The petitioners in the Azimio case is Honorable Raila Odinga, the Right Honorable Raila Odinga, and Honorable Martha Wangari Karua. Those two individuals have a right to be heard in court. They have rightfully filed the petition in court. Now, if Honorable Kuria has a problem with the conduct of the alleged Azimio members or agents or anything, that's a totally different thing. It's a totally different thing. And one wonders, why would he not simply apply perhaps to join the petition as an interested party and present his case, as opposed to filing a fresh petition. Seeking, if what you're saying is correct, seeking that the court should not hear Raila Odinga's and Martha Karwa's petition. You know, one wonders, it baffles me, by the time he was drafting his petition, did he know the contents of Azimio's petition? If you didn't know the contents of their petition, then how therefore do you challenge, how therefore do you ask the court not to hear it? On what basis? All these petitions were filed yesterday. You know, you should at least say, it would make more sense if you said, I have read their petitions concurrently. How do I challenge yours? You get my point. So for me, my take is, if he wanted to file a proper election petition challenging the electoral process, he should have done that. But if he's simply challenging what Raila Odinga and Martha Karwa's petition is saying, then he should file a reply rather than a cross petition.
Okay, so we can say that.
And his is not even a cross petition. It's a petition, because even cross petition is filed in reply to a petition already that is existing. Yes.
So we can term it as a perhaps miscalculated move?
In my view, if it was done by an advocate, then I think there was a mistake in that legal advice. But again, I will be cautious in that, because as I've said, I have not had an occasion to look at that petition. I'm simply actually commenting based on what you say and what people say, but I've not seen the document itself.
Right. There's something you mentioned about all this because they had a whole 7 days window.
Okay, I wouldn't say that there's an advantage. You see, what we are competing with here is strict constitutional timelines. Strict constitutional timelines.
Right.
Remember, we had the declaration was made on, was it Monday?
Yes.
It was Monday.
The 15th.
Then they had up to Monday last week. I mean yesterday to file their petition. 7 days is a very small window. Very small window for such a case of that magnitude. Very small, because you need to do drafting of pleadings, you need to do collection of evidence, you need to do preparation of these witnesses, you need to do just organizational aspect of your case and everything. And this is not a case, a small case maybe in a lower court or a high court. This is a high magnitude case. So there's no advantage in filing in the last day. I think it's a matter of
how will the disagreement between the commissioners affect court ruling? You had touched on that earlier, but perhaps this is a viewer who's just tuned in. He goes on to say, considering the fact that Azimio has filed a petition against the commission as a whole.
Yes. The Azimio has filed, and it's not Azimio that has filed it, is Raila Odinga and Martha Karua. Those are two different petitioners. The petitioners have filed their case, one against the commission. The first respondent is the commission. Then the second to eighth respondents are the individual commissioners. When you are sued as an individual, first, the commission, as a commission, must put in their reply. Each individual commissioner, they can elect to put their reply, but they have a right so to do. Now, when, for example, take for example the four commissioners who did not agree with the chairman and the others, as long as they've been sued in the individual capacities, they have a right to file a reply in the individual capacities. As I said, their reply should not be interpreted as those supporting the petitioner's case. Their reply is to simply, what is the petition saying about us? Okay? What are the accusations about us in the petition? Therefore, we put our reply in defense of that petition. If coincidentally our reply happens to be the same thing that the petitioner is saying, I mean, truth is not a reserve of a few people. If you say, if the petitioner says that this is black, and we also see it as black, and we say so, we are not necessarily supporting the petitioner's case. We are simply stating our case. Yeah.
Okay. Another question coming here from Jeremy, who asks, what's the difference between the 2017 and 2022 petition?
The 2017 and the 2022 petition.
Yeah.
Of course, there are different aspects. I don't know what particular aspect he is asking, but just beginning with the form, in the 2017 election petition, it's only the commission that was sued. This time around, they have gone against the commission as well as the individual commissioners. The second difference that I see is in the prayers. In the prayer sought in the 2017, it was simply the nullification of that electoral process and an order for fresh elections to be issued, to be granted. But this time around, looking at the prayers, the prayers are wide, so wide and very seriously implicating. For example, there are prayers as against the chairman as an individual. A prayer, for example, like him to be held unfit to hold public office. Should that kind of a prayer be granted, there are going to be serious ramifications. Such a prayer was not there in the 2017. There's a prayer of this second difference where the petitioners are asking that a recount be done, and if the recount, not if a recount be done, and the petitioners be declared as validly elected as president and vice and deputy president elect. There was no such prayer in 2017. It's a risky prayer because it almost shows that there's certainty on the part of the petitioners that a recount will reveal a result that is favorable to them. A recount may be done and it still may reveal a different result. So either a recount is done, then let the court make a declaration based on the result, but you will not be declared as a president-elect and deputy-president-elect if the recount does not support that kind of declaration. So there are many other differences. Yeah. We may not have enough time to go
have
through.
A look at
yes.
All right.
Yeah.
And even as we are speaking and looking back at 2017, of course, in comparison with 2022, could we say that the Electoral Commission learned from the presidential election petition then, when we look at how the whole election process was conducted?
This is my personal opinion.
Right.
I wouldn't say they have learned. What I would say is that they simply tried to be smarter.
Okay.
They simply tried to be smarter. As to whether they will be caught is a different case. One of the key issues, one of the key things in the 2017 election petition was opening of the server.
Right.
Which was never opened for reasons that the server was based in France and they were asleep and all those things. And I think the nullification largely was hinged on the fact that there were a lot of undisclosed information. This time round, what the commission told Kenyans is that the server is open for members of the public. Okay? And therefore, it would appear to an ordinary person that they have learned. But looking at the petition, what the petitioners are saying, they're alleging something called staging and dumping. What they're saying is that on the front side, the members of the public were being told, this is the server. Download every form, do your own tallying. Okay? But in the back end, what the petitioners are saying is that when the results were being transmitted from the polling station to Bomas, they were intercepted in the back end by a person of interest. This person manipulated the results in his favor, okay, or whichever way he wanted the manipulation to go. Then it is after that manipulation that he now posted the manipulated results to the server. So that the members of the public, when we went to the server, we were not getting results directly from the polling station. We were getting results that had been manipulated in the back end. So looking at that, I would not say if that is true, and if the petitioners are able, and I hope they prove, because that's a very serious allegation. Such an allegation was actually made during by President Trump when in his election, I think against President the current president Biden.
Right.
And the Attorney General actually dismissed that allegation. So it's a very serious allegation. If Azimio is able to prove that allegation, then you can really not say that the commission learned. What you gather is that this is a commission that had seen this is where we slept on our job last time, this manipulation job. This time round, we are going to up our game, hoping that they will not catch us. To say that that was a lesson learned, I think would be very unfortunate. But if the allegations are untrue, then I think we can say that they learned lessons. Yes.
All right. You've mentioned about, of course, the petition mentioning that the whole process was intercepted and interfered with in favor of a particular candidate. looking at, of course, the IEBC Commission, 2017, there are those who as well resigned when the whole election process was ongoing, as well as the following year. We look at this year, we see 4 commissioners also stepping aside and saying we are not part of that. If Chebukati is declared unfit to hold office, what plays out next?
Now, it's a serious prayer with serious ramifications. The good thing with being a party to a case, especially a petitioner, is you don't have the burden to bother yourself with what will happen. You have to simply ask for prayers. Give me this prayer, give me this prayer. But the court will have a serious duty to ask itself, this prayer is justified. This person may have been found to be unfit to hold office, but should we declare him as such? What is the implication? If you remember, in 2017, there's a judgment that Justice Odunga gave in the eve of the election. He said that the returning officers and some of the preceding officers the process of their appointment was unconstitutional. Nevertheless, he did not go ahead to declare them unfit to conduct that election. If the Supreme Court declares the chairman to be unfit to hold public office, I think what we'll be facing is a possible constitutional crisis moment, because if, for example, the election results are invalidated by law, by the Constitution, we have 60 days within which to conduct a fresh election. Now, if there is no chairman, and the chairman by law must be a lawyer, we will have to get a new chairman. I don't know whether we have the capacity as a nation, the executive, to actually conduct a fresh process, get a chairman, and let this chairman be conversant with this, with the electoral process, with what is demanded, and hold a fresh election within 60. I think it will be quite difficult. Again, I will say not necessarily, not insurmountable, but very difficult.
Very difficult.
So I think before the court issues that judgment, as much justified as that prayer may be, but before the court gives that prayer, it will have to seriously consider what are the ramifications that this judgment is going to give to the nation. Yeah.
If he still holds office, and of course you're speaking from a point of if, then the court declares a repeat of election with Chebukati still as the chair. Are we seeing a repeat of 2017 with, of course, Raila Odinga then deciding to boycott the repeat of election? And here comes, of course, him filing a petition, probably declared a repeat of election with Chebukati as the chair.
It's hard to tell. It's hard to tell. That's a very political. The decision to boycott the election was political.
Right.
Again, they have he has his right to make such kind of political moves. Politically, he has also been perceived as being favored by the state this time around. Politically,
true.
Whether boycotting the election will favor him politically is a totally different thing. The circumstances as it is now are very different from the circumstances as they were in the previous election. And I think it was understandable the other time, because the person who bungled the election, which has been invalidated, is the same person who is going to handle the repeat election.
Right.
And the executive was appearing to be in support of that person then. That set of facts is now different from the current set of facts. I think I will leave it to him to be politically advised whether boycotting or proceeding will be what will give him the most desirable results. But again, he has his rights. He has a right to make any political. The problem with these things is that a presidential election, and every election for that matter, is as much political as it is legal. And sometimes I think the members of the public may find it difficult to understand, or sometimes it's actually just difficult to have the law sorting out political issues. That sometimes we may be having a very serious political dilemma that a strict application of the law may not solve it. So I think that's a political question. And he will need political advice to make a political decision.
I think it's a matter of wait and see.
Yes, it's a matter of wait and see.
Again, let me also follow it up with another political question. Here comes, of course, the petition filed by Raila Odinga and Martha Karua. Then let's say the court doesn't rule in their favor and the elections are upheld. What next for Raila Odinga?
What next for Raila Odinga? I think what next for the nation first is that we'll have Honorable Ruto sworn in the next Tuesday following the 7th day after that judgment. So the nation will move on. The swearing in will proceed and Ruto will take over the instruments of power and life will move on. To Raila Odinga, it has been said that this was his last bullet politically. But this is a man that has had 9 lives. This is a man that, if you observe his life keenly, when you think he has now been beaten so much, then he rises up in a manner that politically he just still gains relevance. I think my personal opinion is that I have not seen any Kenyan, and I don't know whether we'll ever find a Kenyan who has so much contributed so richly to the jurisprudence of our presidential election, the law around it, the development around it, the progress around it. I think that by the virtue of him constantly running for presidential elections, constantly being defeated, choosing to address his grievances through different ways, and lately now through court, I think for me as an individual, what next for him is left to us. Are we as a nation appreciative enough to actually see the sacrifices and the contribution that our statesmen make for our own progress as a nation? Or will we be left to laugh at him? I don't know. What he will, as an individual, I don't know what he will do. Whether he will come back, I can't rule him out. He has proven time and again that he can't be ruled out. But this time around, I think the burden shifts to us as Kenyans, examining him, looking at him as an individual. Even if he loses now his political relevance, can we look back as a nation and ask ourselves, this man has contributed so immensely to the progress of our democracy, to the jurisprudence of our presidential elections. What can we say to him? I think there is our burden as a nation. His decision as an individual, that will be him and his family.
Okay. Here's a question from my producer. If Azimio wins, what happens next? If indeed they do a retallying and they see indeed, the election outcome was in favor of them, I think then you touched on that earlier, saying that then the Supreme Court will order the IBC to... Two options.
If a retallying and a recounting is done and it reveals that the Right Honorable Raila Odinga and Martha Karua were the rightful victors, then as I said, the jury is still out, but my opinion is that the court has powers to order the commission to issue them with the certificates, and after that they will be sworn in as president and deputy president-elect on the 7th, the first Tuesday following the 7 days. That's the first option. But again, they may win in another way. They may win in that the elections are nullified and a fresh election is directed. So we will see which prayer the court will, because if you look at their prayers, they've also been crafted very, they've been very, I think, wise in their crafting of their prayers. There's this, we are asking for this prayer, but should you deny us this prayer, then in the alternative, give us this. So we are asking that the elections, we are asking that we be declared the rightful winners. But should you deny us that, then give us a nullification of the result and take us to fresh elections. So whichever way the court will rule, it will be a win. If the court rules this way, there's a different path. If the court rules this way, there will be a different path.
All right. As we come to a conclusion of this session, of course, speaking about the presidential election petition, in itself, would you say is a right step towards, say, democracy, having in mind that, of course, then this also causes a bit of anxiety and tension amongst the electorate?
By all means. By all means. It's commendable, it's progressive, it's beautiful. We are gaining the respect of the entire globe. We are gaining our own respect back as a nation, because we may want to ask ourselves, what is the other alternative? And if we ask ourselves what's the other alternative, the only answer we have is 207 to 8, the 92, all those post-election clashes. So by all means, I think that post-election violences are largely caused by want of justice in our electoral system.
Okay.
If we have, and if we are willing to strengthen our institutions, the commission and the judiciary, in a manner that they can help us achieve electoral justice, then I think the anxiety is something we should be willing to live with.
Okay.
Because the other alternative is too costly for us as a nation. Yeah.
I think that's very well put. Mr. Victor, what will be your parting shot? Of course, here we are waiting to see how everything will play out. What do you leave our viewers with today?
My parting shot is we just have the petitions only so far. I think it is too soon to celebrate. It is too soon to say that the case is so strong. Or at a prima facie level, the case is strong. But again, as I said, Proverbs 18 verses 17. The first one to present his case always appear to be truthful until another person comes to ask him questions.
Okay.
Let us wait for the respondents. Let them present their case. Let us wait for the court to conduct a hearing. As we have maintained the peace, let us continue to be peaceful as we await the Supreme Court decision. That's what I can say.
Okay, before I let you go, here's a question. Do we see a clear petition this time than that of 2017? A clear petition. A clear petition.
I've gone through the petition, especially the Azimio petition. I think it's clear. And as I've said, from my perspective as a lawyer, they have established a prima facie case, meaning that if what they have said is not responded to, then their petition qualifies to annul the election. It is clear. It is understandable. It is simple. The key thing is they have a burden to prove that which they have said.
All right.
So I think it is. Yeah.
And what is the possibility of the Supreme Court nullifying an election again?
As I said, the question should be probability. There is every election petition is treated independently.
Okay.
Remember when the Maraga bench was nullifying election, they said that they direct the commission to conduct a fresh election within 60 days in strict conformity with the law. And he added that, should you fail to do so, we shall not hesitate to nullify another. Meaning that even the repeat election, they were ready to nullify it should it not meet the legal threshold.
Right.
So every election petition is treated independently, and if there are grounds to nullify it, there should be no ground to fail to nullify just because we have nullified a lot of them. No. Every petition is independent of each other, and it is the law, the facts, and the evidence. If a nullification is warranted, it will be warranted, even if it means nullifying a series of three consecutive ones. Yes.
All right. I think another question comes here. It's what we've touched on as well. The 2017 petition process was not so much clear. Do we see now a petition that is clear? I think you've touched on that.
It is.
Similarity questions on both our social media platforms. Thank you so much, Mr. Victor. I think we now wait for the 15th of September to hear the verdict.
To hear the verdict of the Supreme Court.
Right.
Thank you so much also, Faith, for having me.
All right.
I'm very grateful. Yes.
Okay, my producer has an interesting question here about the amicus curiae. Right.
Yes. Amicus curiae is, in ordinary language, a friend of the court.
Okay.
The other time, it was the Honorable Attorney General, Mr. Gidu Muigai, as he then was, SC, who applied to be an amicus. We don't know whether Honorable Kihara Kariuki will do so this time round, but it is an application seeking to be given a platform to say what you want to say to the court. Now, if you are given a chance to be an amicus in such a kind of a petition, you are not coming to support the petitioner or the respondents. You are saying that I have necessary and important information that will help the court in analyzing the facts, the evidence, and making a judgment. You are for neither party.
Yeah.
Yes. So we will see whether we'll be having such kind of applications this time around.
Okay.
Yes.
Thank you so much. I think further discussion on that we had, of course, off air, as the team behind tries to also understand these legal terms. Probably another program as well for Kenyans in general, to be able to be at par and understand as well, even as we look forward to follow the proceedings live. All right, thank you to you, dear viewers, as well, for your questions, interaction with us. I really do appreciate it. We're taking a very short break, but keep it right here because Kirk Mid Morning continues after this short break.
Are you looking to grow your business? Kirk TV offers you a variety of advertising opportunities to suit your budget. Advertise with us today and reach your potential customers countrywide. For more information, email us on sales@kirktv.org or call 011 00 90 647.
Choose life that you may love the Lord your God.
If you delight yourself in the Lord, He will make you fruitful in whatever season you are in.
Listen to His voice and hold fast to Him.
That as disciples ourselves, we're being invited to be transformed more fully every single day.
In our walk with God, let us know that we are assured victory in every battle.
For the Lord is your life.
Live a pure life. Are you living a righteous life before the Lord? It is possible. People are wondering, can you do without corruption? Yes, I can stand and say it is possible to do without corruption.
Don't miss season 2 of the evening epilogue every day at 9:30 p.m. only on Kirk TV.
A mistake. I am not a mistake. Welcome to Kirk Watoto. We're very glad to have you. In this show, we have 4 segments.
I always get excited for this particular moment when we raise generation for Christ.
You know that Jesus loves you so much and He has given you talents.
The aim of this program is to make sure that it nurtures your talent.
By the kuwa na baraka si pesa mingi, ni kuwa na Yesu ndani ya moyo wako na kujipenda na kujua ya kwamba you are not a mistake.
Wow! Let's do this. Let all the children come to me, because in the name.
I'm Celestine Kemunto. I'm taking a bachelor's in business information technology. I chose ZTech because, first of all, ZTech has been ranked among the best in ICT, and I thought it will be best. It will be best for my course. First of all, there are so many ICT labs in ZTech University, which enables students, mostly those who are pursuing IT courses, to get to know more about their courses. of which the labs have so many computers which have Ethernet, which is easier for them to browse. If I were given a chance to choose another university, I'll definitely choose ZTech University.
Apply today. ZTech University. Invent your future.
Get the very best Christian television here on Kirk TV.
It's such an honor and a privilege to have you on board.
And I'm delighted to bring us the Word of God.
Be nourished holistically with our program lineup from Matters Health.
The health of women, mothers and children is a very fundamental and key area to invest and focus in.
Faith.
Bless all of us, Lord. Bless the whole country of Kenya.
Family.
We stay here and transform families, stable families,
for stable society. Educational.
To educate you, help you and learn new laws.
Kazi na mali. Sisi ndisi.
It is junior talent in the program called Kirk Watoto.
As well as national issues.
In our part as a national government, we will continue to cooperate with like-minded stakeholders.
Experience it all here on Kirk TV.
Thank you so much for tuning in.
Alright, so welcome back to Kirk Mid Morning, and thank you so much for keeping it right here. We are about to wrap it up, but before we do, let's have a look at the sports sector very briefly and look at yesterday's game. A big win for Manchester United, who picked up their first win of the season yesterday night with a 2-1 victory over Liverpool at Old Trafford. Jadon Sancho and Marcus Rashford were the heroes for the home side, bagging in either half to send the home crowd wild, with Mohamed Salah netting a consolation for the visiting Reds in the closing stages. Now, Man United bounced back to a bad start of the season with 2 losses, including the hammering of 4-0 by Brentford. Man United now sits 14th on the EPL table. Definitely a big win for Manchester United yesterday night. Fans of the team on social media making a big deal out of it. Our social media manager Lee, who supports the Liverpool team, of course, did not have quite a big smile on his face. However, we look forward to this Saturday where Manchester United faces Southampton and wait to see how things go. Right about now, allow me to wrap up today's program right here. Thank you so much for tuning in and being with us till this far. My name is Faith Kaulu, but I'll be leaving you with a feature by our very own award-winning health reporter Ida Monzatzi on the most abused painkiller, diclofenac, the deadly painkiller. So keep it right here. Do not go too far. But from me right now, it is goodbye for now. See you again this Thursday, Kirk Mid Morning, same time, same place. Goodbye.
are so many people consuming diclofenac, and there are so many companies producing diclofenac to increase their sales.
The Ministry of Health has warned against the use of diclofenac without a prescription from a health practitioner, a drug that is commonly used to relieve pain, inflammation, and joint stiffness caused by arthritis. The Pharmacy and Poisons Board giving an alert and warning that even though the benefits of diclofenac are higher than its risk, if used in high doses and for a prolonged period of time, diclofenac is associated with increased health risks.
Diclofenac zimenidhuru sana tumbo, mambo ya ulcers, contain ulcers.
For many years after Patrick Aholi had a car accident, he became a frequent user of diclofenac to relieve the severe burning pain in his leg. Due to the high doses of the painkiller in his body system, Aholi now suffers from stomach ulcers, yet another pain had to bear.
Hizo diclofenac zilikuwa za machungu, maumivu ya hii mguu yangu. Sasa ndio wananiambia hizo zinasaidia sana hiyo maumivu. Sitasikia. Sasa mimi nani hiyo wakati iliisha hiyo baada ya mwaka moja Kenyatta. Sasa benye nilikuja nyumbani bado nasikia hiyo machungu. Mimi niliendelea tu kumeza hizo dawa za diclofenac. Sasa ndio zimenidhuru mimi mambo ya afya. Nini tumbo, wewe inaniwasha kama niko na njaa. Si kujua. Kuenda kwa daktari ananiambia hizo madawa zilikuwa natumia sana hizo za diclofenac.
Patrick Aholi is just one among thousands of Kenyans who have fallen victims of diclofenac misuse, either knowingly or unknowingly. Many now at risk of heart attacks, strokes, and other cardiovascular diseases. According to an alert issued by the Pharmacy and Poisons Board, there is a small risk of heart attack or stroke in patients taking systematic diclofenac regularly, especially at high doses of 150 milligrams daily for long periods. The alert indicating that diclofenac is no longer recommended for patients with a history of heart attack, stroke, heart failure, blockages of blood vessels to the heart or brain, or have had an operation to clear or bypass such blockages, or circularity problems that restricts blood flow to your limbs. In most cases, when one has some body pain, it's not the negative after effects of a painkiller that matters, but to relieve the pain and feel better. A notion that leads many people to the counter to acquire unprescribed medication, with some even storing the drugs in their houses for emergency, they say.
Yes, sometimes I buy from the counter if it is just as a mild pain. But if it persists, I normally go either to a clinic where I see the doctor and then I'm helped.
The habits or the culture of Kenyans, you find that it's in their genes, so and their mind. Find most of the people, they Google without going to hospital to get the prescriptions, and they just walk to the pharmacy and then they order.
The talk about diclofenac as a painkiller is an insult, but it gets to be misused by many Kenyans. One, anytime a person has a pain, and general body pain, they tend to think that it's only diclofenac that can heal their pain. But it is the role of a pharmacist or a pharmacist or any health worker to advise the general public on the use of any painkiller, and there is also the model in administration of a painkiller.
Now, the habit of acquiring drugs over the counter or unprescribed drugs over the counter is a very common habit amongst Kenyans. Now, with the alarm from the Pharmacy and Poisons Board about the misuse of the diclofenac drug, I'm in the streets of Nairobi and I'll pop into a number of chemists just to see how easy it is to buy diclofenac or to acquire diclofenac over the counter.
Habari yako? Uko na diclofenac? How much? 10 bob moja.
Diclofenac is an nonsteroidal anti-inflammatory drug, meaning it relieves pain, swelling, stiffness, and inflammation.
Uko na diclofenac? Ni how much? 10 bob.
From my visit to a number of chemists, I found out that it's one of the drugs that you can rarely miss in a chemist, costing between 5 Kenyan shillings and 10 Kenyan shillings a tablet. My visit to the chemists around Nairobi continues. In this specific chemist, I buy 2 tablets of diclofenac at 5 Kenyan shillings each.
Ni how much? Moja ni 10. Moja 10. Mbili.
I'm even offered water to take them. I find a way to only drink the water and hide the main tablet.
There are so many people consuming diclofenac and there are so many companies being producing diclofenac to increase their sales. There are so many. So the reason why they are thriving because of that the usage, excessive usage of the molecule. Because one thing they tend to think that it's only diclofenac, even there is a myth that it's only diclofenac that can heal them.
Another group of people who fall victims of diclofenac use are those with underlying medical conditions.
Also, there's chronic condition like people with asthmatic, people with gastritis, whom you cannot administer the diclofenac to. But the public are not aware of the issue.
According to the alert by the Pharmacy and Poisons Board, people who have other risk factors such as high blood pressure, high cholesterol and diabetes should be assessed by a medic on whether they can use the painkiller and how they should use it. As the Pharmacy and Poisons Board create awareness to be held accountable, are not only people who buy diclofenac and other painkillers over the counter, but everyone, including pharmacists and chemists who sell the unprescribed drugs, putting the health and lives of many at risk.
So naweza kusema serikali iangalie pande hiyo. Sisi tunaenda kununua madawa ni kwa sababu hata kupima kwa ile hospitali ya government it's a lot of money. Kwa hivyo unaenda tu una explain your problem, then unapewa hiyo painkiller either ikuzuru ama ikuponye.
Afadhali mtu asinunue painkiller yeyote akisikia kuna uchungu. Asisindi ile daktari anasema if you try for sometimes you check with the doctor so that your sickness may be detected and may be discovered earlier.
Ile waende hospitali wapimwe ile magonjwa wako nayo, ijulikane ni dawa gani haswa utatumia. Si tunaenda tu chemist unanunua dawa unameza. Unanunua dawa unameza. Uende upimwe ujue ni dawa gani utatumia.
There is cases whereby you should not administer and drug like diclofenac. So to the general public, to the general health workers, get to know whom you are giving the diclofenac or even any other painkiller. May it be a Panadol. Someone can be allergic to Panadol. Someone can be allergic to aspirin. Someone can be allergic to the content in aspirin or the content in diclofenac. Get to know what you are giving to the public, so that now you can safeguard the health of the Kenyans whom you are serving.
The bottom line is the word from the Pharmacy and Poisons Board, among other stakeholders in the health sector, warning or advising the public against self-medication with painkillers, especially diclofenac. Now, diclofenac should only be dispensed or used upon a prescription from a duly qualified health practitioner. My name is Aida Munzati for Kirk TV, Nairobi.